Okay, I think we will get started. If anyone's having any issues with Zoom, technical issues, just type it in the chat and we will hopefully be able to get that sorted out for you guys. So welcome everyone to AutismBC Talks on Workplace Accommodation and Supports. We have Disability Alliance BC with us. My name is Sarah. I'm the Vancouver Island Regional Coordinator with AutismBC. And we're really excited to have Margery Pazdor with us today from Disability Alliance BC, and she's a staff lawyer there. She advises clients on a variety of legal issues, including human rights and discrimination. So yeah, I'm really looking forward to this presentation. As Brock said, if you want to type questions in, or Margie will invite you to ask questions when it seems fit for her. We'll just go with the flow. Let us know again if you're having any technical issues. And Margery, thank you so much for being here, and I will pass it over to you.
Thank you, Sarah. I'm very happy to be here with all of you. I just was curious. Oh, wow. Yeah, that's a full second page of people. Okay, exciting with so many of you. So as Sarah said, my name is Margery. I'm a staff lawyer at the Disability Law Clinic at Disability Alliance BC. I started there in March of this year, so about 6 months ago. Prior to joining DABC, I worked at a private law firm which focused on representing and advising employees as well as unions about workplace-related law, including accommodations. And prior to working there, I actually worked for an employers association advising employers about workplace-related law, employment law and labor law, including accommodations. So this is an issue that I've looked at or advised about from the perspective of employees, as well as unions, as well as employers. I grew up in Ktunaxa and Shuswap territory in the East Kootenay region of BC, but I've lived in Coast Salish territory on the land of the Musqueam, Squamish, and Tsleil-Waututh people here in Vancouver for about 12 years, with a break in the middle of about 3 years when I was in Haudenosaunee territory going to law school in Montreal. And if any of you, I'm not sure, Sarah, you mentioned maybe as an introductory thing, we could invite people to share where they're calling in from in the chat. And if you'd like as well, if you want to share, if you're not required to share, of course, but if you want to share if you've ever asked for an accommodation before at work, in the chat, that might be interesting to know how many people are familiar with this process or with what it means to ask for an accommodation. And then I will pause to see if anything came flooding into the chat. I will share my screen and get this presentation rolling. Great. Thank you, Carla and Jason. Okay, I can still see the chat. That's good. So so I'm just getting my little windows lined up so I can see the presentation and I can also see some of your faces still. Okay. So this is my outline of what I plan to talk about today. Of course, the goal of today is to give some information about discrimination and accommodation in the workplace specifically, and discrimination related to disability specifically. But I'll start by saying a little bit about Disability Alliance BC and our services, in case some of you maybe aren't aware of the services that we have, and a little bit about the law clinic. And then we'll talk about human rights law and how it defines disability and how it defines discrimination. And then we'll get into the question of what accommodation is and how it works and what kinds of accommodation you can ask for. And also what to do if your employer refuses to provide accommodation. So the goal of today is to provide some legal information to people. It shouldn't be taken as advice. And of course, we can't generally comment on individual situations, but I will have some resources at the end of places you can go for more specific advice to hopefully get some legal advice on a specific situation if you are in need of that. Just going to pause to catch up on the chat because I see a lot of people have responded, which is very exciting.
Lots of great things that came through the chat. People are either applying for or interested in accommodations. We have some people who have been refused accommodations when they've asked in the past. We have people who are coming looking for appropriate wording or appropriate language or terms of like best practices of how to be able to do that. So I will write down other things in the chat and we can keep those for questions, or when appropriate, we're able to unmute ourselves. I've left that ability for everyone to be able to ask questions during the presentation, because this session is really for people who have joined.
Great, thank you. Thank you, Brock, for that summary. Okay, I think I'm caught up. All right, moving on to the introduction into DABC. Many of you, there we go, I skipped one. So Disability Alliance BC has been around for a long time, about 40 years, as I understand. It used to be called the BC Coalition of People with Disabilities. And in the first sort of half of the organization's existence, the focus was more on systemic advocacy and big picture advocacy, but for about the last 20 years, we've been offering direct services, and those services are more the focus of the organization now. The mission broadly is to support people with all disabilities to live with dignity, independence, and as equal and full participants in the communities. So it's a provincial cross-disability voice. And for the direct services, there are 4 programs in particular that I'll talk about. Some of you may already be aware of these. I know Sarah and Brock, you're aware of these, but one of our programs is Advocacy Access, and that helps people apply for the Persons with Disabilities benefit, as well as the Canada Pension Plan Disability Benefit, so PWD and CPPD. We also have Access RDSP, which helps people apply for the disability tax credit and also helps people set up a registered disability savings plan. And then in order to apply for the disability tax credit, a person needs to have filed their taxes. So we also have Tax Aid, which helps low-income people with disabilities to file their taxes and really specializes in supporting people who have not filed taxes for many years. And we also have the Right Fit program, which is sort of a matching program that helps wheelchair users find affordable, accessible homes in the Vancouver area. So one's a little more regional specific, but the rest of the programs we can offer services across BC. I just looked up and saw the question, how many years is considered many? I think that's a question about tax aid, and I don't know the answer to that. I'd have to ask the tax aid people that. Sorry that I don't have a better answer. It's a good question. And then another program that DABC offers, of course, is the Disability Law Clinic. We've been open since February 2020, so we're into our 3rd year now. And what we offer is summary legal advice and legal information, as well as referrals to other legal resources about a number of different areas of law. We can't answer questions about all areas of law, unfortunately. We don't know everything about all areas of law, but we do have a number of different areas of law that we can provide some advice about. And generally what we can offer is, like I said, a summary advice session. So it's sort of a 1 or maybe a bit longer, 1 hour or a bit longer session with a lawyer to get some advice about a specific situation that someone might be dealing with. And we have a list on our website of the specific areas of law that we're able to give advice about. And then, like I said, we also have, we also can provide referrals to other resources. Sometimes it's hard, there's so many resources out there. Sometimes it's hard to know what the best one is. And we can sometimes give some insight on that. So that is my introduction about DABC and our services. I'll pause to let Brock let me know if there's anything in the chat you think I should respond to right away. I saw a few things come in, but I wasn't able to keep up with what they were saying.
No questions about that right now.
Okay, great. Okay. All right. So then on to the main event, talking about discrimination and accommodation. Today's presentation can be summarized in 2 sentences. First, the BC Human Rights Code protects against discrimination based on disability in the workplace. Sounds pretty simple. The second, the employer's duty to avoid discrimination includes a duty to provide reasonable accommodation up to the point of undue hardship. So I've bolded some words and phrases in there, and these are the words and phrases we'll spend a little bit more time on. So we'll talk about what the word discrimination means in the context of human rights law, as well as the word disability. And then this phrase, the duty to provide reasonable accommodation, what does that mean? What is that obligation or that duty? And what does it mean that an employer only has to provide accommodation up to the point of undue hardship? So we'll talk a bit about what undue hardship means. So that first sentence, the BC Human Rights Code protects against discrimination based on disability in the workplace. So human rights law protects people from discrimination on the basis of disability. And in this context, disability includes mental disabilities, physical disabilities, learning disabilities. It includes invisible disabilities as well as visible disabilities. It includes intermittent disabilities. It includes both temporary and permanent disabilities. So if someone is injured or has a serious illness and they're unable to work for a period of time, or they require something to assist them to work for a certain period of time while they recover from the injury or illness, that's a temporary disability, but it's still protected by the code, as well as there might be something that someone requires accommodation on a longer term or forever, like there's no expectation they ever won't need that accommodation. That is also protected. Human rights law also protect people from disability based on perceived disability. So even if you don't have a disability, if someone thinks you do or makes an assumption about something that's happening and assumes that it's related to a disability, and then they discriminate against you based on that assumption or that perception, that's still discrimination. That's still protected by the Human Rights Code. And all of these protections apply to other environments as well. We're focusing today on discrimination in the workplace, but the code also protects people from discrimination in other areas of life, like housing, like in rentals or co-ops or condos, and public services and facilities, like hotels or restaurants or schools or any other business that provides services to the public. They're all covered by the Human Rights Code. But today we'll just talk about employment. Are there any questions so far about that? I'll pause so that people can write a question, and I'll read what Anthony shared because it seems interesting. Oh, great. Yeah, really great. I don't see anything else coming in. You can send a question anytime, and you know, we can either answer it in a moment or later, so that's fine. The next word in this sentence that we'll move on to, same sentence, the BC Human Rights Code protects against discrimination based on disability in the workplace, but what does discrimination mean? Sometimes I think people use the word discrimination to refer to any time they're treated differently than someone else, but that's not always discrimination in the context of human rights law. So in the context of human rights law, discrimination is an action or a decision related to a person's disability that causes a negative impact. So there's 3 things there. There's an action of some kind or a decision. There's a negative impact that results, and there's a connection to the disability. Those 3 things have to be present in order for there to be discrimination. And this definition also applies to actions or decisions related to other things that are protected by the Human Rights Code. So the Human Rights Code protects against discrimination on the basis of disability, but also race and religion and sex and sexual orientation and various other things. but today we're just talking about disability. So in the workplace, examples of things that could constitute discrimination include someone losing their job, or an employer changing someone's job in a way that reduces their salary or their responsibilities. It could include harassment or even assault, either by the employer directly or by someone else in the workplace, like an employee or customers. And it can also include failing to offer reasonable accommodation. So not offering reasonable accommodation is a form of discrimination because it results in a negative impact on someone that's connected to their disability. We're going to move on to the second sentence now, but I'll pause in case there are any questions so far. Also, I will check the time. Okay, doing well on time.
Two really good questions there.
Yes.
So specifically in relation to autism, there's a huge service gap for right to adult diagnosis. And we've seen a big uptake on self-diagnose because there just aren't service providers, or it's like very costly. So Jody asks, if you don't have a formal diagnosis, do you still have the same rights?
Yes, great question. And yes, you don't need a diagnosis to ask for accommodation. You do need to be able to explain, and you might need, and I'll say a little bit more about this later in the presentation, you might need a doctor to provide some information about the nature of any limitations or restrictions that require accommodation, but you don't need a diagnosis for that.
And then secondly, there was a private message that came in. Do you have to disclose your diagnosis to be able to fit that discrimination?
You do not.
Because it has to, it's linked to your disability, right?
Right, but you don't need to disclose your diagnosis.
Okay.
I'll say a little bit more about that a little bit later on, but I don't mind saying as often as possible, you do not need to disclose your diagnosis. I also have a question. So yes, another example that could be on this list, examples of actions that could be discrimination, are not hiring someone. So the question is, if someone isn't hired based on their poor interview skills, could that be discrimination? And I think all of these things are very context specific, but certainly a decision that is taken that has a negative impact, not getting a job that's related to a disability, could definitely be discrimination. And then there's a bigger question: how do you manage this? Do you disclose on the disability or on a resume? This is a very good question, and I think I might have to come back to that one because I think it's a bigger question, which I might speak to a little bit later in the presentation. But whether I address it directly in the presentation or not, I'll try to come back to that question. Just writing it down.
Okay, and then one more question. Debbie asked, what happens if you think that you're being accommodated by giving less hours, but then the workplace increases your hours without consulting you, because that can lead to higher burnout? And I think that, yeah.
So that's tricky. I mean, if there's a formal accommodation in place, there should be some written record of that. There should be either a written agreement of some kind. Well, there should be a written agreement of some kind about what accommodation has been offered and what that looks like. And that shouldn't be changed without consultation. I think if it were changed without consultation, that would be a decision that potentially, if it does cause a negative impact and it's related to disability, I think that definition might be met, that definition of discrimination. With every, in every situation, there's always, everything has to be kind of considered in the whole wider context. So without knowing a lot more specifics about that situation, it's hard to say specifically. But certainly if you have a formal accommodation agreement in place, or you've been formally offered and accepted accommodation, that shouldn't be changed without consultation. I see another question. Okay, I think I'll be talking more about the accommodation process a little bit later in the presentation. So I think some of these questions we might address a little bit. So I might move on for now. Thank you everyone for your questions. All right, the next sentence, an employer's duty to avoid discrimination includes a duty to provide reasonable accommodation up to the point of undue hardship. So what is the duty to provide reasonable accommodation? Sometimes treating people fairly means treating them differently from others. That's why the law includes a duty to accommodate. And what that means is the employer has a responsibility to take reasonable steps to provide accommodations that an employee needs to do their job. And what's reasonable depends on the situation. All of these laws are, whenever they're applied or interpreted to a specific set of facts, it's always very, very context specific. And all of the different factors of a particular context are taken into consideration. So what's reasonable will depend on the situation. And we'll talk a little bit more about this in the next slide as well. But it is an important word because it's reasonable accommodation that's required. It's not perfect accommodation, or it's not exactly the accommodation that someone has requested. It's a reasonable accommodation. And sometimes those things line up. Sometimes what you request is reasonable and the employer is able to provide it, and that's great. Sometimes they don't. And so that's what the law requires, is reasonable accommodation rather than perfect accommodation. And the thing about that is, if you're in a process where you're asking for accommodation and something reasonable is offered, an employee can't reject that reasonable offer unless they have a good reason, or unless they have a way to show it's not actually a reasonable offer. So I think that's something that's important for folks to know. Oh, I think did I go backwards? Oh no, I didn't go backwards. Okay. So some examples of what might be reasonable accommodations, depending on the situation, could be various things related to modifying your duties or the structure of what you're doing at work, like having more breaks throughout the day or having more frequent check-ins between an employee and a supervisor, or changing how information is shared, for example, by putting it in writing instead of giving it verbally. So that might be directions that are given, or it might be feedback that's given. I saw somebody earlier mentioned they had asked to have interview questions provided ahead of time, and that request was honored by the potential employer. I think that's a great example also. Accommodations could include modifying the work area, so the workstation, either moving the workstation to a different area, perhaps quieter, or things like monitor setup and keyboards and mice and chairs and desks and all of that stuff. Or changes to lighting. It can be providing special equipment, again, that workplace, that's workstation equipment, or things like noise canceling headphones. It can also be as simple as giving time off, whether that's to access treatment, like to go to appointments, or it could be a longer leave of absence for any reason. That is also a form of accommodation. I'll just pause because I saw some more contributions coming in through the chat. Oh, another great resource shared.
Jason has a really great question, and it links to the lack of service providers and medical professionals that understand autistic expression and like autistic mental health literacy. None of the doctors that they've spoken to are familiar with autistic burnout, which means that they can't get medical evidence about restrictions or limitations in related to autistic burnout. So do you have any suggestions of how to get an accommodation if you can't find a healthcare provider that can provide medical evidence for restrictions or limitations.
Maybe. I mean, I think I would have suggestions in the abstract. I don't know. It might be that everything I say is something that Jason has tried and has run up against a roadblock about. This is obviously a huge challenge. I don't know. I don't know how to address the problem of the lack of literacy in the medical community. But I would say that generally, if you're asking for an accommodation, so the first step is to ask and provide what information you can. The employer might, and often they do, ask for essentially medical confirmation of what you're describing as sort of the reasons for the accommodation that you need. Sometimes I think you might depends on the pardon me, it depends on the questions that they ask, but the questions are often very they're quite general, and they're really about, I mean, they're aimed in a very, obviously very medically oriented, so they're really about asking about restrictions or limitations, or even like symptoms would be sort of a word that they're often asking about, which doesn't always apply. But I think even if you can talk to your family doctor about what you're experiencing, if they themselves are not familiar with autistic burnout, I think certainly some family doctors, I think, would be willing to essentially take what you're telling them and, you know, fill out the form accordingly. If a doctor is not willing to do that, it's really hard to comment generally, I think.
Yeah,
without...
that's and I will share with everyone afterwards. We talked with Dr. Jonathan Weiss, who just like this April made the Autistic Mental Health Literacy Guide. And that hasn't been shared a lot to a lot of other doctors. And I'm hoping that that helps train more people with understanding autistic mental health literacy, so that we have more service providers that are available in BC. Carla suggested sometimes reaching out to an OT could provide a letter because it has to do with your occupation. So we'll pause that question. Thank you.
Thanks, Brock. That's a great suggestion also. Thanks, Carla. All right. What are my responsibilities as an employee? So how do you get an accommodation? That's really the question here. And the first thing is you need to ask for it. So you need to tell your employer that you need accommodation. You don't need to share your diagnosis to get accommodation. I said this earlier. You don't even need to have a diagnosis to ask for accommodation. You do need to be able to provide enough information about your individual circumstances to justify the accommodation that you're seeking. I'm looking at my notes and I'm hearing myself about to be repetitive, but I'm going to go through the notes anyway, because some of these things have come up during questions. So your employer might ask you to get a form filled out by your doctor, and if so, and if there's a fee associated with that, they should pay for that. They're not allowed to ask for your diagnosis. That's not information they're allowed to ask for, but they are allowed to ask for details about any restrictions or limitations you have that might impact your work. And you have to provide it either through you or through a medical professional. And then the other obligation that you have as an employee, as I said before, is to consider any accommodation offers from the employer. Assume they're made in good faith and give them a fair chance. And then obviously if they don't work and you have a good reason why they don't work, you should say so. But if there isn't anything that prevents it from being a reasonable accommodation, then you should go along with it. And the other thing you have to do is notify your employer when changes are required. So if something changes in your situation or changes for you, or if it's not working in some way. I mean, I think generally a good accommodation plan should always have check-ins. So if an employer knows what they're doing, which they don't always, you know, they'll set something up, they'll make an offer, and they'll say, we're going to check in on this in 3 months and see how it's working and see if we need to adjust it. And maybe we'll check in again in 6 months and again, see if it's working and see if we need to adjust it. So ideally that's set up and that's happening. If it's not, and you realize it's not working, or if you realize you don't need it anymore, like whatever is happening, you should let your employer know, and then you can make the changes as needed. And it's always best when you're communicating with your employer about accommodation as much as possible to do so in writing, so that you both have a clear record of what's been discussed and requested. And for the employer, if you ask for accommodation, your employer should gather information about what it is that you need. And that might, as I said, involve asking for medical information. It might not. It depends on what you're asking for and how complicated it is, how easy it is to provide. It depends on the employer and how formally they want to follow certain steps. But they do need to gather information, and they need to consider what accommodations they can reasonably offer, including if, depending on the situation, including if there isn't something they can offer for the particular position that someone has, they even have to consider if there are other positions that could work, that they could offer someone. They have to respond to your request in a timely manner, and they have to maintain confidentiality about your request and your disability. So somebody mentioned that earlier about providing medical information. I think the comment was about providing it to a college. And so you don't have to tell people your diagnosis, but you are going to be providing sensitive information to the employer, and the employer has an obligation to keep that confidential and to not spread that around the workplace, both about your request, the fact that you asked for accommodation, and about your disability, or about the information that you've shared about why you need the accommodation. And most importantly, they can't reject your request without considering it first. And unfortunately, I know this sometimes happens. And when that happens, that's an employer not meeting their obligations under human rights law. They have to consider the accommodation. They have to consider what they can reasonably offer. I mentioned they don't have to provide perfect accommodation, and as the sentence that we're covering says, they only have to provide accommodation up to the point of undue hardship. We'll talk about undue hardship next, but they do have to consider it. So just an immediate rejection without consideration is a pretty good sign that they're not meeting their obligations, and that is probably discrimination. Employers also, last thing I'll mention, they also actually have a duty to inquire. And so that means if they notice a change, or if they have reason to suspect that disability might be a factor in something that's going on at the workplace, like maybe someone's not performing the way they expect them to, or the way they used to, or something, and they think there might be a disability related reason, the employer actually has an obligation to ask. And they don't have they shouldn't come up to you and say, do you have a disability? Is that what's going on? But they should invite you to share if you need accommodation in any way. And that sometimes is an opportunity to share that if you haven't asked for it yet, but maybe you need to. Oh, that was actually the next slide. I jumped ahead of myself. So yeah, even if you haven't asked for accommodation in the past, they have an obligation to inquire if they notice that you're struggling at work. I think I'll finish the part about undue hardship before I check in on questions again, in case this answers some. Sorry, I went too far. So the next sentence, so the sentence that we're covering, an employer's duty to avoid discrimination includes the duty to provide reasonable accommodation up to the point of undue hardship. So undue hardship is the limit. If providing a particular accommodation will result in undue hardship on the employer, they don't have to provide it, and it's not discrimination for them to not provide that accommodation. That's rare. Undue hardship is rare. Usually employers can accommodate an employee's disability without undue hardship. It's always very context specific, depends on the specific situation, but it's pretty rare. There's no specific definition of what constitutes undue hardship. It's just sort of a vague term we're all supposed to understand. But there are a number of factors that the law considers when deciding whether or not something constitutes undue hardship. So they consider the financial cost of the accommodation. And you consider that in the context of the specific employer and the specific workplace. So a large employer with a lot of resources, it's going to have to be a pretty high cost for that to be undue hardship, but a very, very small employer without a lot of resources, they might have a limited amount of what they can spend before they experience undue hardship. So those things are considered. Health and safety risks associated with the accommodation. So the thing that I thought of about it is if something results in somebody working alone when it's not safe for them to do so. The impact on the rights and interests of other workers is another factor that's considered. And that's not about inconvenience. That's not about other workers not liking something or being a bit inconvenient by something. It really has to be a significant impact on the rights and interests of other workers. And somebody mentioned unions earlier in the chat. And if you happen to work in a unionized environment, it's really important that the union be involved in these conversations. They actually have an obligation to accommodate as well. And they can act as your advocate in these conversations. One of the options, if your employer refuses to accommodate, is to file a grievance with the union if you're in a unionized environment. But also the union actually has to agree to accommodations if they impact the rights of other unionized workers. So they actually have to be part of the conversation. Next slide. Keep going too far ahead. I'd like to pause. I see there are 50 new messages that I haven't seen. Brock, are there any that you want to flag?
Yeah, there were a few questions that did come in. What if an employer is given a accommodation, but the co-workers are not either told about that or also upholding that? Because it kind of is on that line of you're not supposed to tell or share in the office, but also the accommodation should be upheld, and it might be linking to the co-workers.
So hard to answer that in a general way. I think if that's something that's happening, my suggestion would be to bring that up with the employer, with the manager or supervisor, and sort of try to problem solve what messaging they can provide to the other employees to make sure that it is upheld and that obviously the things are still kept confidential. Because it is ultimately the employer's responsibility to make sure that an accommodation is working and is actually being provided, and that might include providing direction to other employees or providing. I mean, it's just ultimately their responsibility. But I think I appreciate it that it can be challenging to think about how do you make that happen without disclosing something that shouldn't be disclosed, but it is possible.
Yeah, thank you. So the duty to accommodate falls on the employer, and should the employer then still be taking into consideration like your requests for accommodation, or is that entirely like the employer says, oh, we've made this accommodation, this is reasonable to us?
It is their obligation to provide the accommodation. I think a reasonable employer should consider your request. Like if you ask for something specific, the employer is not necessarily obligated to provide that specific thing. They're obligated to gather information, consider what accommodation they can offer, and offer a reasonable accommodation. If it's different from the specific thing that you asked for, and they say, well, this is reasonable, they're not the only people that get to decide what's reasonable. You also can consider, well, no, that's not reasonable, and here's why. It doesn't meet this need that I have. It doesn't address this concern or this reason that I asked for the accommodation. If that's the case, then I would say it might not be a reasonable accommodation. So there needs sometimes to be a conversation like that, but sometimes it is a reasonable accommodation. Sometimes it's not exactly what someone asked for, but it does meet all of the needs that they've shared. But actually, dropping things on my desk. But actually, that's sort of this first point in this slide. So what if your employer refuses to accommodate you? So the first step, I think, is always to just continue communicating. So you might need to go back to your employer and explain why the accommodation isn't reasonable. Maybe they didn't understand the first time, so you need to communicate again. And it might mean communicating with healthcare providers, as somebody mentioned earlier. Maybe having an OT provide information rather than a doctor might provide better information for an employer to understand why a particular accommodation is needed. So hopefully that sort of conversation, that communication helps resolve the issue. But sometimes even after multiple requests and clear accommodations, you still aren't getting either accommodated at all or getting accommodated in a way that actually meets, actually provides accommodation, meets your needs. And in that case, if you are in a unionized environment, you should definitely speak to your union representative about potentially filing a grievance. You can also consider submitting a human rights complaint. And I always recommend seeking legal advice about your situation. I know this is challenging because access to legal services is not straight. There's not a lot of access to legal services. But because human rights and accommodation law, it's so specific to the situation, I think if it's possible, it's really beneficial to get a legal opinion about how the law would apply to your specific situation. And to answer, for example, that question, Brock, of is the accommodation the employer's offered actually reasonable? Like, would the law see it that way? Sometimes I think it's just good to get a legal opinion about that. Of course, submitting a human rights complaint or taking legal action is a pretty adversarial step to take. So that presents practical challenges sometimes if you have an ongoing employment relationship with someone. But it is an option.
And the second part of that, is there a reasonable timeline for the employer to meet that accommodation? So if you ask and then it's the duty of the employer to accommodate, what if they're going oh yeah, we have the duty to inquire, so we're trying to figure out what's going to work best for us and you, and then that goes on 1, 2, 3 months. Any advice on moving things forward?
Other than continuing to follow up and just continuing to engage in the conversation, and don't let it sit, don't wait for the, continue to follow up with the employer, keep yourself high on their priority list. I don't have specific recommendations about that. I think you used the term, does the employer have the obligation to provide accommodation within a reasonable time frame? And I thought to myself, yes, but the definition of what is reasonable is dependent again on the situation. So I can't say.
Okay, yeah, no hard and fast rules then. Yeah.
Yeah.
Okay.
Yeah. There are hard and fast rules about when you need to make a complaint to a human rights tribunal if you were to consider doing that. And that is that it has to be done within 1 year of the event occurring or the last event. So an accommodation situation might be several conversations all related to the accommodation, culminating in not receiving accommodation or perhaps even losing your job. And so whatever that last event is, you'd have to file a complaint within 1 year of that. And I just have some links here because if anyone was considering submitting a human rights complaint, there's actually 2 different places you might do that. For most employers in BC, you would go to the BC Human Rights Tribunal. So these are employers who are regulated by the provincial government and by provincial employment legislation. But for employers who are regulated by the federal government, which includes banks and radio and television broadcasting, those complaints would have to go to the Canadian Human Rights Commission. I just have links on the slide there. I also have the names of some organizations where you might be able to get legal advice about your specific situation. So there's us, the Disability Law Clinic. I have our contact information on the next slide. We do have, unfortunately, a very lengthy wait list at the moment, which we do have a plan to shorten the wait list and be able to respond to people in a more timely way, but we're, I think, a few months away from getting to that point. For human rights questions, there's also the Human Rights Clinic at CLASS, the Community Legal Assistance Society. I just blanked on what the A stands for, but the Human Rights Clinic at CLASS is another option. They provide summary legal advice, and they also, I think, can sometimes provide representation once a claim is filed and accepted by the clinic. Access Pro Bono is another great resource because they can also provide referrals to lawyers who specialize in labor and employment law. Sometimes you have to pay for those services, but if you're able to do that, they're a good referral service to connect you to lawyers with the appropriate expertise. And then the Law Students Legal Advice Program is another resource to consider for information and advice. And one thing I'll say about the Disability Law Clinic is just that we can only help in cases, or we can only provide advice to people who are not members of unions. So really, if you're in a union, like, they are your first and main line of advocacy and assistance. So, and they might also require follow-up, I'll just say as a general statement. Sometimes you need to continually follow up with the union representative to get their support as well. I'm going to pause and check in on questions. But we're very near the end. Maybe I won't pause. Maybe I'll just say a little bit more about some other resources. So the Disability Alliance BC produced a resource called the Disclosure Guide. So the title is Disclosing Your Disability, a Legal Guide for People with Disabilities in BC. And it kind of addresses this question that somebody asked early on, I think, about when to disclose, especially around interviews. There's no hard and fast rule for that. I think the general principle is if you're applying for a job where your disability is not likely to impact your ability to do the job at all, or like you won't require accommodation, then there's no need for anybody to know. If there's a chance you might require accommodation, then it's something to think about. And I think certainly if you would want accommodation during the interview process, I mean, that's another thing to think about also in terms of when to disclose or how to disclose. But that guide has a lot of good information and it's available on our website. And then the People's Law School also has some information about the duty to accommodate, and I have the link on the slide there as well. Now I'm going to pause for questions because that's pretty much the end, except for some information about how to contact DABC.
There was one question that came in about accessing accommodation without needing those medical practitioners or disclosing their medical information or history. Is there any possibility of doing that, or is it you need that medical professional's opinion?
There's always a possibility if you ask and the employer is willing to provide without any medical information. But I think if the employer is asking for medical information, I'm trying to imagine if there's a situation I can think of where it wouldn't be reasonable for them to ask. Nothing's coming to mind. I think generally an employee has an obligation to provide medical information if the employer asks for it, assuming that the information they're asking for is reasonable and is not asking for a diagnosis or other things that they're not allowed to ask for. Like they're not allowed to ask for specific treatment or specific information, except for how the disability might impact your ability to do your job.
Okay. In your
questions.
Yeah, in your experience, do you have any suggested accommodations for addressing attitudinal behaviors faced by the autistic community? For example, like other people cannot read facial expressions or hold back on the career because they believe that you're aloof or angry or not a team player, and people are just like unaware of autistic traits. This is one that might be better for the AutismBC team to answer. They're like, it's building up society awareness and then society exception. Like the listening and learning from other autistic individuals is extremely powerful. And I know that we had autistic self-advocate Trudy Gould, who explained like stimming and eye contact in the workplace and in community. And we've shared that with so many people that they've been like, you know what, 30 years ago, I was taught you need to be able to look at somebody and you can't be doing these things, or these aren't appropriate workplace behaviors. And she was like, they're not. Like, I'm trying to be able to listen to you. I'm listening to you way better if I'm not staring at you. And it's just like having that community awareness breeds that community exception. But I don't know from a legal standpoint. I think it's like a community learning perspective that we need to shift.
I think you're probably right.
So currently at the Disability Alliance Law Clinic, you have like a few month backlog of people that are reaching out to you. Do you have any idea or general idea of like how long it takes to be able to respond to new people that are sending messages through?
It
varies.
It varies. Yeah.
Okay. There was one question.
Sorry,
Okay,
go ahead.
Sarah, you go ahead.
Regarding the long wait times for legal representation, is there any legislation that obligates firms to provide advocacy to those facing financial barriers?
No, there isn't.
There was one question that came up like nearer to the beginning of the presentation when we were talking about changing roles for accommodation might have to do with modifying duties, which seemed to contradict one of the previous points of like asking for accommodation could be like facing discrimination. Like, this is it, you're changing my role, or you're making this role different to be able to accommodate me.
I was thinking more if that happened, not like outside of an accommodation process.
Okay.
So someone being demoted, for example, could be discrimination, but someone engaging in an accommodation process and developing developing modified duties or a modified work schedule, which might perhaps even result in less pay, but if that's done as part of an accommodation process with the agreement of everybody involved, that wouldn't be an example of discrimination. But if somebody just gets demoted or moved to a different shift that has fewer hours outside of that process, that could potentially be discrimination if it's has a negative impact and is related to the disability.
Okay. Yeah. So it's not if it's like the job was started in a different role than what like a posted job said. Like, if that's okay. I think it's too many layers of that one. I want to get back to people's questions. Sarah, do you see any other questions that are here? if people have questions, this is the opportunity to be able to unmute. I will also share the slides with a follow-up feedback survey for everyone. And then later on this week, probably Friday, I can share the recording so people can go back. There was a lot of great information here. I was taking notes, but I have a hard time taking notes and fully paying attention. So it's always great. Thank you for letting us keep a recording of the session and continue this conversation.
Yeah, we have a hand up. Carla, go ahead.
I'm just wondering about the duty to accommodate and undue hardship. Is there not also an issue in regards, for instance, with colleges and universities that up to the point where you can provide, hard to explain here, the accommodations up to the point you don't want to cause any problems for the integrity of the program or the employment? Is that a second reason that it could be turned down for the accommodations?
Yeah, that could be something that's, well, so yeah, the education context is a bit different. So I was just trying to think about how what you said about integrity of the employment, how that would apply in an accommodation question. No, I think that's a very education specific question as to whether that results in undue hardship. I don't think I can answer that.
So what about the core competencies of the job that maybe you don't continue to have the core competencies, and accommodations may not meet the ability to bring that up to the level where it can be done?
So in the employment context, what I would say an employer has an obligation to do is look at indeed those core competencies, and only those core competencies, not extra duties that someone might be doing that aren't really related to the core of their job. Consider whether someone is able to do those things with or without accommodation. If it's without accommodation, great. If not, then consider, can they do these things with accommodation? What kind of accommodation would they need to be able to do these things? If the answer is no, there's no accommodation possible, or potentially if the answer is if the accommodation that is possible would impose undue hardship, then the next step would be, is there another job or another position that might be possible for this person to, that we could potentially offer to this person that they would be able to meet the core competencies of, again, with or without accommodations. They actually have to look through all the options, consider the core competencies of all of those options, consider accommodation for any of those options, which is one of the reasons I think it's pretty rare to get to the point really of undue hardship, because there are so many moments and opportunities for what accommodation could be offered. And it's just rare that truly there isn't anything, or truly there's nothing that wouldn't impose undue hardship. Does that answer the question, sort of?
Yeah, thank you. You mentioned that it's good to have a document that has the accommodation request, or like a written agreement of accommodation. Do you have like a template of that, or is there a template that you can share, or will they all kind of look different? It would just like, it would be really helpful to know additional resource to provide, like, here are some autism specific examples or workplace specific examples of accommodation agreements that kind of new employers could learn. I think the President's Group might have some of those, but a template would be helpful for people to learn.
I don't have a template. I'm not aware of one. It's a good question. I've written it down to follow up and see if I can find anything. I think every employer is likely to have their own. So bigger employers like a health authority or a government, like they'll all have templates internally. They're all going to look different. Really, I mean, it can look like a lot of different things. You just need some sort of document that demonstrates. I mean, first you want to document that you've asked for the accommodation. So that's going to be different than your accommodation agreement or the agreement about what you what you've said you'll do or what the employer has said they'll do, but you want to document the whole process as much as possible. So communicating via email as much as possible, or if you're having meetings, making sure to make notes afterwards about what you talked about at that meeting, what the date was, who was there, what was agreed, what was offered. But yeah, it can be as simple as a letter, just outlining what you've agreed to. It can be more formal, more formally like an agreement, you know, structured more like some kind of contract. I'm sure there are templates that exist.
Okay. And would that
but
be?
I don't have one.
That's the onus there is on the employer then to be able to have those, not the employee who's asking for them. Like I shouldn't
That's
go into a meeting and say and start taking notes and be like, this has to be in my HR folder or something.
The obligation to keep records or to have an agreement?
To
template.
have the agreement, yeah.
I think the obligation to have the agreement is on the employer. I think it's smart for an employee to make sure that any accommodation agreement that has been reached is documented.
Okay, nice.
But there are lots of employers out there that don't necessarily do what they're supposed to do. So it's smart for you to protect yourself, to make sure that there's a document that records what was agreed to in some form for yourself, that the employer has it. Sure, that it's in your personnel file, it should definitely be there, but it is their obligation. You just might need to help them.
Nice, that's
do what
that's
they're
great.
supposed to do.
Yeah, thank you.
And I'll look for possibly a template that I might be able to include with a follow-up email as well. I'll see if I can find anything and some suggestions on reasonable accommodation as well. Now, would people be able to go to you guys if they wanted help drafting up that original, like the first request, whether it be by email, or where could they go for some help with that?
So we're not able to write letters on people's behalf or like act for them. We just don't have the resources, unfortunately. We can set up, like I said, a 1-hour consultation. If in that consultation you bring a letter, and we might be able to give you feedback during that hour, but we're not able to write letters for people. Just gonna...
Okay, if anyone has any further questions, we can take them now, or we can start to wrap up. Thank you so much, Margery. That was very informative. I know even I learned a lot, so really appreciate your time today.
You're welcome. I really appreciate everyone's contributions. I haven't been able to keep up on them, but there's been some really interesting comments and things that have been shared. So it's really great to be part of such an active, like to be in a presentation where there's such an active community and active.
Yeah, this was great. And I will send
attendees. There we go.
a follow-up email with information. If anyone has any further requests for information, they can email us. I'll just type my email in the chat if there's any extra links or anything you want me to provide as well.